Yeah.
So
Okay.
this is Laws 12065, Foundations of Property Law, the tutorial covering topic 7, Public Lands, Land Rights of Indigenous Peoples, and an Introduction to Native Title. And this is 2nd of May 2014, and we're in week 9, but we're covering topic 7. Yeah, sorry, Margaret, you just want to go back to the point you wrote?
Yeah. I was just talking about the final exam. I will be in Brisbane at that time. I have to go down for a court case. I think it will still be right because I can, do the online assignment down there.
Yeah.
But just I don't know which particular day. I know it's the end of May anyway at this
Yeah,
point.
no, look, and welcome, Lisa. I think Lisa's just joined us. Look, I put that there to just emphasise to people that, this. I've adopted as many people would know, many students in the course would know, I've responded to different situations that were arising for different individuals in terms of completion of the quiz. First quiz, for example, we had floods and we had goodness knows what, we had cyclones and so on. And there were also some technical issues with Moodle, which I fully appreciated impacting upon, people's ability to complete and so on. So I was a bit flexible there, but I just wanted to I put that there just to indicate to people that there'd be, a more strict approach to the timing of the final exam. But of course, and I didn't say this, but of course, applications for, in the normal way for reasons of misadventure or for, that might justify a deferral of exam or something in the normal way according to policy, of course, that's acceptable. And if a person has particular circumstances, then they can put them to me or put them through the system. But I just wanted to try and reinforce the point that it was important for people to appreciate that a bit of a more strict approach was needed to be adopted with regard to the final, because otherwise things just get a bit out of hand. And, we want to make sure that people get their final, the final piece of assessment done, get them on the system or through Moodle, and then I can start the process of marking, because if there's delay and all that sort of thing, it just causes too many issues. So that was really the purpose of that last sentence. Yeah, but if there are particular justified reasons consistent with policy, then that's fine. You just need to put those through the system whenever. Lisa was there, but is she still there? Can't see her. Okay. Just you and me at the moment, Margaret. It's a critical time, I think, within the term cycle, as always. But the fact that the recording, the fact that the class is recorded means that people can view it subsequently, that's the benefit of the recording.
I was interested in that the Cliff property case as well, the Israel-Palestine one that you did put up.
Yeah. It's I'm really, wanting to expand people's vista in terms of thinking about the issues. I think at times, particularly, there's Lisa. Lisa's joined us again. Hi, Lisa. That people, that's right, you've got a bit of internet issues, that's fine. People can become very, caught up with the technicality of how the matrix of the law and the principles and the rules govern situations, and it's all about that. It's all about, detailed problem solving and legal interests and equitable interests and trusts and all. Look, it is about that. This is I'm not going to shy away from the fact that it is a huge, huge course, and it's embracing a wide field. But I always consider it important and appropriate for my students to encourage them to raise their eyes to the broader landscape, and particularly, when the themes that we're touching on in this topic, the significance of them are not just contained within Australia. And, you know, one of the reasons I gave you the quotation that I did in the second problem, where Brennan refers to international law, was to get you to think about the broader implications of these sort of issues. And of course, the nature of the disputes in Israel or in that territory that embraces Israel and Palestine, although Palestine is not actually a recognised state, but it does have recognition of a kind through the United Nations, and all of the issues with regard to land settlement and the fractious nature of how that takes place. I mean, it just is indicative that there are these sort of property and land-based issues and tensions that traverse the globe. I mean, and in your response to the second question, Margaret, quite rightly, you've you know, looked at the idea of dispossession. Well, this has, you know, in this context, you know, dramatically and sadly affected our Indigenous peoples, but there's been dispossession taking place around the globe in various parts of the world. One can argue for, you know, virtually for millennia. We've already seen earlier in the course, through my introduction of material in relation to South Africa and the reference to Section 25 of the South African Constitution about the dispossession not of Indigenous people but of black Africans, and the query there about whether they are equivalent Indigenous to Aboriginal folk in Australia or Aboriginal Torres Strait Islanders in Australia. You know, that's another debate to take place. There's also, you know, the dispossession of people in Europe during the wars, the Jews being dispossessed of their properties, you know, without a by your leave by certain powers, and then attempts after the war to come back and reclaim. I was only watching, for example, a program, you know, not even in Europe, but a program on SBS. I don't know whether you ever watched the Global Village program on SBS, which is quite an interesting program in my view. It was looking at, I think it was Patagonia, down at the southern tip of South America, of Argentina, and looking at examples there of the dispossession of people when, you know, there was a change of political regime. And then the descendants of those people, and they weren't Indigenous people, but the descendants of those people, grandchildren, trying to reclaim land that they felt had been wrongly taken for particular political reasons. I mean, you know, so these issues and fights and contests about ownership of land and entitlements, it's a global issue, basically. So, yeah, that's the point of me giving some extra things for you to think about. Yeah. All right, look, we might make a start. Small group today. I just want to make sure I get the attendance, so I'll just put that down. We might or might not get others to join us, we'll see. All right, so just a little bit overview. So basically, today's topic has two component parts to it, I suppose. The first really is looking at how the state, that is the political state, not the state of Queensland, for example, the political state, as I indicated in my notes there, operates as both regulator, landholder, and the grantor of properties. And when we talk about the concept of the political state, Grant's just joined us. Welcome, Grant. You know, we get into this environment of thinking about the Crown and what's the context of the Crown's involvement. The Crown is still there, as we know. It is still very much in the frame, if I can use that way of putting it. There is a fiction, in my view, about what that means when we refer to the Crown, but it is still there in many ways. And we can talk about, for example, in terms of the public context of ownership and so on, we can talk about the Crown in right of the Commonwealth, and we can talk about, for example, the Crown in right of Queensland. We know that the Crown also is represented through her, currently, representatives at federal or at Commonwealth and state state level. So the manifestations of the Crown are still very much part of the structure, but there's also a fiction associated with what do we mean by the Crown. Certainly, the sovereign doesn't come in and operate unilaterally with respect to their interests in any area, and couldn't do so. And if they tried to do so, then we'd suddenly have a constitutional crisis on our hands. But we see that in the area of property law, that the embodiment of the state, the political state, has a variety of ways of functioning. And sometimes it's arguable, of course, that these things lead us into areas of conflict of interest. This is why, of course, that for those of you, in Queensland, may be following what's going on in New South Wales with regard to ICAC, the Independent Commission Against Corruption, but this happens in other parts of the country as well. But the ICAC body is actually a very strong body in terms of what it can do and how it goes about its inquiries. It's because these political entities, these political persons, who are also vested with authority and office within the structures and institutions of government, that they are then approached and lobbied by those who want to curry favour with them to benefit themselves. And as we know, particularly in the area of land and property development, and a couple of even in the posts to the questions, particularly to the first problem question, one student referred to an interesting implications with regard to DAs, development applications, and yes, council has a role to play in development applications, and what if and so forth in terms of that. So we need to see the various ways in which the state operates and functions, and that these don't always necessarily sit together. But in this topic, we are thinking about the source of title or private title. We're asking some questions about the nature of the residuary holder of land where some form of limited title is granted. The idea of land being held for a purpose, this comes out in the Bathurst City Council case, and also in that first case of Davies and Littlejohn, which is an early High Court decision, 1923, where the land is being held for a public purpose. But what does that mean? How is that documented? And what are the restrictions on what the public entity or the government of the day can do and not do? And also, as hinting, this point I was referring to a bit earlier in my reference to ICAC, the government of the day operates as the regulator of the development and use of land, so development applications and what can be done with land and so on and so forth. And this is a very vexed question at times, and a lot of interests are in play, and those that have the responsibility of ultimate decision making have to be very careful that they aren't subjected to influence. But of course, many of them fail that test, and we see that happening on a regular basis because they're often not very robust, either not very robust in that regard or not really interested in being very robust because self-interest requires them not to be. So from there, we then move on, and that first discussion also takes us back in again to the idea of the trust. Michael, welcome. Hopefully got a good mic this time. I think you had a few issues last time. So that again takes us back into the idea of the trust and the charitable trust in particular. And from there, of course, we then move on to the very significant theme of native title, the landmark decision of Mabo No. 2, and what that meant in terms of the recognition of native title under the common law. And I specifically have excluded the native title legislation from this topic, and we'll come back to that in the first week of land law when we'll look at the native title legislation. And I've broken up the treatment of native title and the way land law is dealing with the rights of Indigenous people in this way, so that there's a progressive learning and a progressive understanding. Because one of the strategies of our program, the CQU program, is to provide an enhanced focus on indigenisation. And I believe that this is a strategy which I've tried to develop in this course and in both of my courses to give a greater opportunity for my students to reflect upon and think about these issues over a couple of different topics, and indeed over a couple of courses, rather than just sticking it into one topic and then moving on. I think it's so significant that we have to do it in that way, and it's also, as I said, part of the strategies of this university to enhance the idea of indigenisation. And just looking at that in terms of the general law and the common law and what that means, but not looking at native title. Just before we progress, just one point on that. When I say, and this is now, I'm saying this with an exam focus, I suppose. When I say, or when you read in the information that's provided, you are to consider something, with respect to some particular framework of law, or you are not to consider some framework of law, you are to take those statements with complete seriousness. I'm not saying it lightly or frivolously. Okay, I do not want you to consider these other things for reasons. So that, for example, in the quiz, question 3, I specifically said you are to consider the nature of whatever interests you determined were at play against and in accordance with the general law framework, not with respect to any systems of registration of land interests or etc., whatever that may mean. Right? And yet some students continue to tell me about, well, of course you would register your interest, wouldn't you? Well, that's irrelevant to the question, because the question specifically asks you to focus on general law, to take you away from those other areas that are dealing with a system of registered interests. So just a point to remember, to read the question carefully, always looking for the keywords, but in terms of what you're required to do, read that carefully and focus on the task at hand, basically, and be succinct and concise in the way that you tackle that with appropriate and adequate support from the law. All right, without further ado, let us then proceed to the tutorial problems. And we've had a few students post responses to those, which is good. I know it's a heavy traffic time of the course, of the term, I suppose is a good way to put it. A lot of demands on people fulfilling assessments and so on and so forth. But still good to get those posts up there if you can. If you haven't had a chance to do that, although I think all of you have, just for the purpose of the recording, up until the end of this week, I'm still happy to look at any posts to tutorial problem questions up to the end of week 9. That's fine, including, the topics that we haven't yet done, but on, up till the end of week 9 for the purposes of class participation assessment. So let's go to problem 14. Now, problem 14 is getting you to focus on that first section of the topic. That is the nature of the role of government, the nature of the role of the interest that the government of the day or the state has in land, and what if it's been given land or land's been transferred to it with some provisos or some restrictions on what can do. What's the role of legislation in that restriction process, if any? And it also tosses up the idea of the significance of the concept of the trust, which, as you know, is the most fully developed form of equitable interest. So, problem 14, over to you, people. I can see all mics muted. All right, that's fine. It's, look, is anyone going to...
I'll put in a comment. G'day.
Grant, thank you, Grant. Yeah.
G'day. I actually read this material 2 weeks ago, and I'm just looking at my notes, and I'm a little bit simplistic. But I was referring to the Attorney General's case, the Perpetual Trustees case, that the concept of the charitable trust, it's over public lands. The council is holding it for the beneficiaries, which are the people. And for the citizens, they don't have a right to the land per se, other than a right to use the land, which I guess is still a right. But something that I was reflecting on was legislation can modify those rights. So even though the council is required to provide those rights, the question, this is now a question that I have, is there any, when it comes to a trust, is there any reason why the government simply can't legislate to deny those rights and to transfer the land?
Mm-hmm. That's a good question, Grant. I'll come back to that question just momentarily, and please make sure I do come back to that question because it's an important one and I want to respond to it. This question, if you've got it open in front of you, all right, let's look for in the information, like in the quotation, right? Whenever you're given a quotation, let's look for the key words, the key concepts before we get to what you're being asked to examine with respect to the quotation, right? We already know, so we're looking for keywords and we're looking for context. We know that it comes from a particular case, so clearly we need to go back and focus on what that case was about, and we'll do that just in a minute. But looking back to the quotation, what would you say were the keywords?
Trust, government responsibility, the obligation, the statutory trust, well, it's quotation, but not the trusted person, but for statutory purposes.
Yeah. So all of those key words. So, and then drawing out from that, what would you say this quotation is trying to struggle with?
The conflict between ownership rights versus the use of rights, or the limitations of what you can do within a trust.
That might be so, but there's another, I would argue, a more primary contest in play. Notice that the quotation refers to a trust obligation as understood in private law, right? How do we
conflict?
Yeah. How do we normally conceive of property law and property rights? What branch of law do we normally associate it with?
With estates, private ownership.
Private law. Okay. We tend to divide the legal landscape into private law and public law, and then we divide it into things like civil law and criminal law. Property law tends to be, historically, categorised as part of private law. But we've seen in previous topics that to some degree this categorisation is a bit artificial. It's artificial because, for example, the idea of land tenure in Australia cannot be adequately understood just by considering private law notions. So Margaret asked a question beginning before others joined about the idea of allodialism. That very easy word to say. And we know that the idea of land ownership in Australia derives from, as we discussed when we looked in that topic, the sovereignty exerted by the British monarch or sovereign at the time of settlement, the radical title that occurred to and was recognised as being in the hands, if you like, of the Crown as a consequence of the assertion of sovereignty. But that is not absolute title, unfettered absolute title, which is what a allodial title is. And a allodial title couldn't exist in England or the UK, I'll say England because that's more correct, since the Norman conquest in the 11th century, because of the way that England became a conquered land.
And that comes into the discussion on tenure.
It does. It's very interesting, isn't it, that I'm talking about England being a conquered land when Australia, of course, was never conquered, it was only settled. The British don't seem to know their history very well, do they? So that's one.
Isn't that an argument in itself as to whether Australia was settled? Because by overturning the doctrine of terra nullius, really, Australia, for all intent and purpose, was like a conquered country, was it not?
I'm sure there are others that can comment on that at this point. Michael?
No, I can't agree with that. I'm sorry. I mean, like, they weren't conquered like as if, like England was, for example. Just moved in and just said, okay, we'll have this place, but they never conquered them because, I mean, the Aboriginal people never ceded the country anyway. They never signed any surrender terms or anything else. So how can it actually be conquered?
I'd probably take the conquering from another point of view, in that the way in which the British came to Australia, ignored the rights of people who were here, used a number of means to really dispossess and displace and disperse people who were here. So for me, that whole issue of the conquering as opposed to the settled, I would have to say it's conquered.
We know that, as Grant's indicated, and thanks for those contributions, Margaret and Michael, very, very helpful, the hugely controversial point, hugely controversial amongst peoples across this country, if they're interested in engaging in the point. Most middle-class Australians who live in comfortable circumstances are not interested in engaging in the point because it might unsettle their comfortable circumstances of living within their capitalist environments that they seem to inhabit on a day-to-day basis, with little regard for the broader history which informs their circumstances of habitation, if I can use that sort of way of putting it. And yet the interesting thing, of course, about a lot of middle Australia is that they themselves have come from very impoverished circumstances, and that's the reason they're here in the first place. But of course, in the modern period, never let it be the case that you could come by boat today, as was the case previously when everyone came by boat. But if you come by boat today, you get turned around and sent somewhere else, maybe even to Cambodia. It's possible. So the idea of whether we're settled or conquered is controversial, and different minds differ about that. Certainly in the law, it's very important, people, when you know, in the context of a legal debate, a legal discussion, be robust. I want to encourage you to be robust in your views and to defend those views, but find some law, find some discourse to defend those views. Otherwise, you will wander into popular debate which is ungrounded in law, and that's not what we're really concerned about. We can be strident in our views and we can have strong opinions, but we need to make sure that they're grounded in academic discourse, in legal materials.
In the decision in Mabo, I know that Brennan talks about settled rather than conquered, but I still think it's a debate that still needs to be had. And if law is flexible and, you know, moves with the times, it may be something that could be looked at and come back to in the future.
The interesting thing about that, thanks for that, the interesting thing about that is, do you think, this is part rhetorical question, you can respond, but it's something to think about. Do you think that members of the High Court were able to own or identify that Australia was a conquered nation?
I think they'll leave that for the legislature.
Oh. Justices are very quick to pull out what I call the legislative card when something becomes a bit difficult. Please also remember that in Mabo, not every justice of the court agreed with the outcome. There's a justice of the court at the time who now is little quoted, surprisingly, probably not surprisingly actually, and that's Justice Dawson. Dawson was in dissent in Mabo and did not agree with the outcome. I don't know whether that means that he agreed with the Privy Council in Rhodesia. If he did, that would be a bit horrific in my view, in terms of, you know, how we understand how we should be living with each other today. But it's always, you know, remember that the court, you know, the court has its own mind about these matters, and the individual justices have their own mind, and that's the reason why I'm adopted the stratagem that I have in the notes to give you the reasoning from the judgment, so you can read what the judges are saying, not some glib one-sentence, one-liner, because that doesn't give justice to something of significance, and it doesn't allow you to struggle with how the court has articulated these ideas. So these are important. Coming back to problem 14, which we've wandered away onto native title, as I suspect we may have, but we'll come back to that, which is good. There's this tension you can see, even in the quotation, before we even get to what you're required to do, between the private law orientation of property rights, and the intrusions, if you like, of public requirements and public obligations. The private law legal notions don't sit necessarily easily with public responsibilities and public obligations of those entrusted to do things in the public interest. And again, this idea of the trust. What does, I don't know, you know, I say this without knowing how many of you have studied the trust course or not, I won't say any more on that at the moment, but the concept of the trust, what does it actually do? What does it achieve in trust law?
I only know about trusts, what I'm learning in this course. I've not done trusts yet.
An open and an honest hand is always appreciated. So the idea of the trust.
Sorry, I was just going to say, is it a separation of ownership and of legal and the equitable rights?
Yes, Lisa, good, very good, thank you. But the purpose is it divides ownership into two, that is legal ownership and beneficial ownership or equitable ownership. In this course, of course, I have given you materials as is appropriate on the evolution and the emergence of the trust. We can't cover the whole sophisticated law of trusts that's evolved, but we do introduce, and we've referred to trusts in various places in the course. So that's what the trust actually does. It divides ownership. It does it because what's going on is someone who had property has given the legal title or the legal ownership to another. This is in the context of express trust, where we have resulting trusts, we have constructive trusts as well. Given title to another for the purpose of benefiting a third who is the beneficiary. But the beneficiary doesn't have the legal title. So the legal title owner can do things with it, can manage the property, can invest the property, but for the benefit of the beneficiary. And then there's a whole body of law that's been developed, you know, explaining that and how that happens. There's even legislation on foot in Queensland, the Trusts Act and so forth, that regulates the powers and the duties of trustees and so on and so forth. But in the context of land held by the public, by the government of the day, does that way in which the trust operates work best? And then the question here is looking at not just the idea of a trust generally, but the idea of a charitable trust, which focuses on purpose for which the trust was created, rather than, possibly benefiting a person as such. And then how this might link back to, in the context of land held in public hands by the government of the day or representatives of the government of the day, at whatever level, and we have different levels of government, of course, the statutory purposes. Notice the last part of the quotation, not a trust for persons, but for statutory purposes. Very often the government of the day operates under the constraint of what legislation permits it to be able to do. Now here again, we have to understand how levels of government function and what powers they have within the overall system of government, with, of course, the monarch or the crown at the apex. Well, the crown doesn't normally operate within constraints of legislation, but again, that's part of the fiction. And mostly what we're looking at is the cascaded down aspects of the government of the day in terms of how it's doing various things and the basis upon which it can do it, and so on and so forth. So the question says, critically discuss the nature of property law rights that arise as a result of the recognition of a charitable trust over public land. In the Bathurst City Council case, what was going on there?
The council wanted to use the land for an operational purpose rather than for what it was intended, which was for the community, so for the public's use and enjoyment.
That idea of operational and community, where did we find that defined?
Was in the Act.
Which
Local
Act?
Government Act.
Yes, thank you. Good. The Local Government Act. So the Local Government Act, and that's an act of which parliament?
The state parliament.
Yeah,
Exactly. So this now takes us into the tiers of government. So basically what you've got is the third tier of government, that's local government, operating under statutory authority of legislation passed by the state parliament. Of course, local government isn't a parliament, but it can pass ordinances and things of that nature, as you would know from your public law studies. But it's operating within the matrix of the Local Government Act, which defines powers and authorities, and even, whatever Local Government Act it is. This happens to be in New South Wales, but in Queensland, the same equivalent legislation that not only defines what the local government authority can do, or council can do, or whatever, but it also would specify what the minister, the state government minister for local government, or whoever that is and however it's described within the various states and territories, what authority they can do. For example, in New South Wales, and in Queensland, I know this has also been the case, there's been amalgamations of councils. Recently, there was an attempt, I know, in Queensland to de-amalgamate, I think, some council areas that had been previously consolidated on the Sunshine Coast to create new local government areas. In New South Wales, and particularly in Sydney, there's sometimes been interventions by the Minister of the Day to actually remove the whole, all the councillors for reasons of corruption or whatever. And then basically put them almost into a caretaker mode until fresh local government elections can be held. So this is the environment within which the power of local government is operating. So as Lisa pointed out, within the Act, there is this difference between community and operational. Now, in the BCC case, there was an attempt by council to take an area of land that was actually adjoined to another parcel of land, and this area of land that was adjoined was actually for the purpose of, originally, for car parking spaces. And they wanted to change this to make it operational, and what would have, if they'd been successful in being able to describe it as operational under the Local Government Act, what could they then have done?
Gives them the power to sell it.
Oh, Kelly, hi.
Choice to sell.
Yes, exactly. So they could then do more, they could actually achieve commercial objectives, couldn't they? Whereas if it remained as community land under that way that was defined and described under the New South Wales Local Government Act of the day, at the time, of course, the legislation can change and be amended and whatever. But it couldn't do that, because if it remained community land, right, if you go down and have a look, for example, on page 15 of my notes, looking at Clause 6 of Schedule 7, land vested in or under the control of a council being land subject to a trust for a public purpose is taken to be classified as community land. So this idea of the public purpose was actually critical to the designation as community, as this area being community land. And that was part of the process whereby the land had originally come into the hands of council from an original private landowner. Right? And then the court had to then ask, well, you know, the nature of this public purpose, you know, is this a charitable trust in the way that the law of trusts understands that? What did the court say about that?
There's a mention that the Court of Appeal pretty much said that the material that they had there, what they had in front of them, didn't demonstrate any express trust.
Exactly. And they're also dealing with this idea of, so that, for example, bottom of 15 onto 16 of my notes, where I indicate the conclusions that the court came to, the term trust in the legislation is apt to include those governmental responsibilities which, while not imposing a trust obligation as understood in private law, may fairly be described as a statutory trust. The trust was not a trust for persons, but for statutory purposes. So what we find is that it's an amalgam. It's an amalgam of a private law concept adapted for public law purposes. It draws on the background understanding of the private law notion, the trust or the charitable trust, but it is specifically understood and defined according to the legislative purpose within which it is contained. So, in my view, this is another good example of where referring to property law as purely private law is, I'm not going to go too far by saying misleading, but it's certainly a bit of a deception by trying to make it look overly simplistic, in my opinion, because property law is infused with both private law and public law notions, invariably. When we get to land law next term, you'll see that we move a bit more into the direction of private law, but, you know, there are still public law features. So, for example, we'll spend, you know, a chunk of time looking at the torrens, system of torrens title. Well, that is a system of land registration, but who administers the system? It's the Land Titles Office, or whatever name is given to that body in the various states and territories, and it, depending on which state and territory you live in, it seems to change fairly frequently depending on political winds and whatever. But that's the body that administers it. It's a public authority or agency that administers the process. We'll come to understand that the quality of indefeasibility of title under Torrens' system of land registration, which lawyers, property lawyers, and we will emphasise and talk about, you know, extensively, it occurs by the administrative act of registering the parcel of land. You acquire these great rights and entitlements and protections by that administrative act. Administrative acts of government officials are themselves part of the environment of public law, because it involves administrative law understanding, it involves public decision making and these sorts of things. So it's a bit of in my view, a fiction to keep banging on about the fact that property law is just private law. Sometimes these divisions are made for reasons of convenience, I suppose. Grant, did we answer your question, or we need to come back to that?
Well, that's in terms of legislating. It's like where the council, in this case, they had to maintain the user's rights for the public purpose. But then, can the government not legislate simply to change that through statute? You're
right. So now that takes us into what's really going on. So we've been dancing around in terms of what I will call the legalities of what's happening here, right? Which we need to do. Good lawyers, we need to do, immerse ourselves in legal principles and legal rules and get fascinated by that and, immersed in that. But if we're a practitioner out there in the real world, what are our clients interested in? Is that what they're interested in? This is a way to get to answer your question, Grant. We're getting there.
Yeah.
If
the client is the council, yes, the council is not concerned with that. The council wants to know what are their legal remedies to find a way to work with that.
What else are they interested in?
Obtaining ownership of the land.
What else are they interested in?
Revenue.
Exactly. Money.
But that's more of a constitutional issue, because just as an aside.
Is it a constitutional issue when we operate under an environment of the government of the day? Think about the government of the day currently, today, 2014. At the federal level, we've just had issued a commission of audit.
But this is not federal, this is state.
Yeah, it is. I'm getting there. This is all about the philosophy of government. So we've got at the federal level a strong philosophical driver that is about user pays and is about the idea of, if you like, finding more innovative and creative ways to get sources of revenue or sources of funding to do things, not just relying on the public purse. Now, what can what is within the sphere of what councils can do to generate revenue rather than just by looking to funding coming from the state government, for example?
They can sell their
they can sell land over which they have entitlements. They can undertake that in have a commercial approach to that. And then, they can say, well, that'll free up the resources to do other things, whatever that means, depending on their political persuasion or whatever they're focusing on. So we've got this issue, and this is particularly at the local government area, or the level, really, this issue between what they are needing to do and focus on as a level of government representing the people on the one hand, which is the public law question, if you like, or the public law issue, with the fact that they need to generate revenue to do the things that they want to do, and that very much links into commercial imperatives. And that's where local government actually find themselves often in difficulty, because that requires them to work with, in a way, for example, what developers want to do, how they want to develop land, and developers want to develop land to make money, not necessarily to create better beautification or better public resources or better green spaces, but to generate revenue, to generate income. Right? Now, getting back to Grant's point about legislation, of course, the local government doesn't pass legislation. Who passes legislation that will have most immediate impact on local government?
The state government.
The state government. The state government, and of course, in most state governments, there is a minister for local government. The minister may have other portfolio responsibilities as well, but, you know, so there's that relationship, political relationship, that is a part and parcel of then the legal framework that then impacts upon what can and can't be done. And if the state government has particular imperatives or particular things it wants to achieve, it can legislate, and the local government of the day may have to live with that in a way. So, yes, we have the legal framework, so and we have the legislation within which we need to operate. We also have the framework of legal principles that are deriving from the case law, okay? But then again, we have this tension between private law principles that have been developed in the courts and public law, and how that works together, where what's essentially happening is that a public authority, like the BCC, is trying to do something with a commercial purpose or commercial aim, if you like, but it's running up against its public interest obligations that in this particular case have been captured through legal documents that actually, property law documents in fact, and also legislation that's requiring them to do certain things with the land. And then you've got the court coming in at the end of it and deciding what should the council really be doing in this case. And that's where you find this focus on, by the court, on the nature of government responsibilities. That's what they're there for. They're there to fulfil the public interest. They're not there to fulfil commercial interest, even though, you know, depending on the political winds of the day, they might be, you know, indirectly or otherwise being encouraged to become more commercially minded in the way they do things. But when we get to push comes to shove, if you like, at the end of the day, they have to focus on the public interest within their zone of control and within their zone of decision making, and that can't be negotiated away. Any final?
It was interesting. It was interesting last night on ABC. I think they were talking about the state in Victoria, about the Premier, and funding a person who he owns a racehorse with. But the whole rationale was this business creates a lot of jobs.
Oh.
And you know, so it was sort of the public good and the private good operating in the one context.
We have a former Minister of the Crown, and I use that title lightly in this state, that inhabits a $10 million mansion and drives a $200,000 top-of-the-line motor vehicle. But spent a good deal of his life on the backbench. And of course, such a salary from a backbencher politician, you understand, would absolutely be able to justify and fund that sort of existence. Huge questions. Huge questions. And that becomes about politics rather than about law. But the sad reality, people, and I have to just, I think it's fair to own this to you, is that lawyers are involved in the mix of all this at the end of the day. Down here in New South Wales, in again, just referring briefly again to the ICAC, it's not only politicians hauled up before this body, but lawyers who are in the mix of everything. And their hands in everything and whatever is going on and so on and so forth. So unfortunately, we have colleagues in the profession who use their skills and their education, their training in those ways, which is not really what your education is designed for, in my opinion. All right, given the time, let's let's move on from problem 14. Problem 15. So this takes us into native title and Mabo number 2. So I'm happy just to cede the floor to whoever would like to open up the debate on Mabo and problem number 15 and native title.
I think the argument in Mabo actually sort of comes down to what is socially recognised as a society. They sort of just came in and totally denied the Aboriginal people of any recognition of being a functional society.
That's an interesting observation, Kelly, and I'm interested to hear if anyone else has got a response to that, but also what conception of society should we have, and what conception of society did we have?
Well, I think, as I said in my answer, was that we looked at 1770 in the first footsteps upon shores of Australia by Captain Cook and Co. And then some 150 years later, we see the decision in Rhodesia. And still today, we still see elements of that, those kind of attitudes present within Australian society. But the whole notion of terror.
Can you just read for us that quotation from Southern Rhodesia, please?
I've only got the notes that you've provided for us.
Yep, that's fine.
It's idle to impute to such people some shadow of the rights known to our law, and native peoples may be so low in the scale of social organisation.
What's people's initial reaction to a statement like that, which is a statement from the Privy Council, which is at the time and continuingly, but not for Australia, a very superior court in the colonial imperial judicial hierarchy, and up until 1976, appeals to the Privy Council went from all final superior courts in Australia, even when the High Court still existed. What are people's thoughts? Anyone like to respond or have a comment about that statement by the Privy Council in Southern Rhodesia?
Michael, it's Grant. I've got in my notes specifically about that comment that the view expressed in Southern Rhodesia, it does not represent modern day Australia, although there are certainly minority groups that no doubt still have this view. I was sort of expressing an opinion that the majority of Australians are more ignorant or dismissive as opposed to holding that view. So to me, the underlying theme was also about how the common law, as per what Brennan was saying, needs to adapt and change, and that views expressed like that, they may have been, whether they were appropriate or not back then, it is simply not the case today.
I do take your point, Grant, and ignorance is one of the, to me, one of the major factors why some opinions like that still occur.
I think the views of Lord Sumner were probably indicative of the views of the day. Today, I think the majority of Australians would find those views abhorrent. So very, very outdated.
Which people, Lisa, would you choose to ask?
Who would I choose to ask? I don't know, maybe my friends. Middle class, I don't know, white Australians. I haven't come across anybody that would, look, I don't disagree that there are probably minority groups, but that perhaps would agree still with Lord Sumner, although I just can't imagine it.
What about the young men that fueled the race riots in Sydney a few years ago?
Okay, yes, they probably belong to that minority group.
How would people sitting in a detention centre, for example, waiting to be processed, having come from a situation of civil conflict where their lives are in danger, how would they respond to Lord Sumner's views and also to Brennan's views, do you think?
Based on what they see and what is in front of them, and the way that they're treated, they would no doubt take an opinion that Australia still has those views, and that's their perception might be that that's the majority of Australians.
How could that be? I mean, surely Australia is a civilised society living in the modern period with, you know, a population that is thoughtful and reflective about human rights, and this has also been embraced by the international community, as Brennan recognises.
So then
We have Kelly first, then Grant.
I was going to say, I don't think the laws have caught up with social views. We're still under the monarchy, and our laws are very embedded in Old English ideals and perceptions of what we should and shouldn't see as the right thing to do, even though I guess society's ideas of native title are quite different to what they were hundreds of years ago. I just think, and our courts are governed by the legislation and by these years of English law, so it's they're sort of stuck and they can't really curve it probably to what social ideas are at the moment.
Would you say that even of the Mabo decision itself, Kelly?
I think that was a turning point. It was the start. Everyone refers back to it, and it seems to be a celebration that our laws did finally catch up a tiny bit, but it needs to probably keep moving.
Grant, did you want to add something to that?
I would probably divert the discussion more towards the political landscape and the concept of representative government. We have a government representing the people who don't necessarily represent the views of the people, but people are disengaged from the government and disengaged from politics. People are influenced by what they see in the media and often make most of their decisions based on what they see in particularly tabloid media. So again, I don't think that as individuals, when facts are presented to sort of middle class Australia and in fact the majority of Australians, that they would find these things abhorrent. But it's easier to sort of stick your head in the sand and simply ignore it and, you know, follow the tabloid TV, watch the sort of the government for whatever their political motivations are in promoting sort of, you know, this invasion by boat people. For whatever their political purpose is, but that's what the majority of people see on TV, and that's what they respond to.
So do we have a very low estimation of our colleagues and of our contemporaries in the populace?
I won't say we, but I'll certainly say I have a generally very low view of Australia's engagement in everything from politics, human rights, you name it.
It's interesting how the descendants from the first boat people seem to have this view that the current boat people should be pushed back out to sea and not allowed in here. I mean, what's the difference basically? The first boat people, or settlers, whatever you want to call them, they came in here illegally, they weren't invited, and they dispossessed the first Australians, who were the original inhabitants, and basically got rid of all their rules and customs and then just took over the place. And personally, I think the Native Title Act doesn't go far enough. I think it really should. That's why a lot of people perhaps are comfortable with it, because they can sit there and know that their houses, because it's freehold, they're not going to be touched and whatever. But still, there was all those people they were dispossessed. Where's their rights going to where are they going to be redressed for what happened to them or to their predecessors? It doesn't really address anything there, does it?
It's a good point. It's a good point. You know, I'm going to come back to something in the question in a moment, because remember, it's as I mentioned earlier, when you're given questions like this, you do need to develop robust arguments, and you can become passionate in those arguments, both orally and in writing, but you need to keep grounding yourself in law, because that's what we will become or are. We are not just mere travellers showing an interest in these things. And at the end of the day, your degree will make you a lawyer. What that means at the end of the day, people, is that your mind will be conditioned and you will forever be a lawyer. And it doesn't matter whether you practice the law or what you do with it, it is a conditioning of thinking. And one of the reasons why, general people, the populace find lawyers, I mean, they try to, if I can put it like this, dumb it down by criticising lawyers and so forth. That's their first plank of defence. But the truth of the matter is, what they find difficult is the degree to which lawyers are analytical and they dissect information and detail and then analyse it and then put it back together and so on and so forth. That's what your training should equip you to do in a whole range of ways, both clinically with regard to a legal problem that requires an answer against the law, and broader, as we are moving into in this debate, broader political, social, moral, ethical themes and textures that necessarily is the outworking of a deeper and more reflective understanding of what law means. What about the point in the question, in the problem question, and identified in the judgment of Brennan, of this link between international law and common law? What, anyone got some thoughts on that?
Well, I took that to mean that, the weight and the value and the opinion of the international views upon something that was propounded in common law, like we see in Southern Rhodesia, is that the international field will look at it and judge also where countries sit in relation to their laws and the currency of those laws, or whether they operate within a field that's contrary to some of the international standards, for example, discrimination.
Yes.
Because I think that was one of the biggest, well, that wasn't the biggest, but it was one of the issues that was highlighted, was how this continuance of denial of native title rights would sit in relation to racial discrimination acts.
It might be arguable, and I cannot put it any stronger than that some of the basis of Brennan's decision lying in a concern for the current milieu with regard to racial discrimination. I wonder whether that might be, there might be the prospect of that needing to be reconsidered, not the decision, but just that premise, given the current federal government's intentions of revisiting critical aspects of the Racial Discrimination Act, which is causing a bit of a furor in various quarters within our society at the moment. I just want to take you back beyond the quotation in the question with regard, which Margaret has correctly identified, back to Southern Rhodesia, and move beyond that to, if you've got my notes there with the extracts from Brennan's judgment, the top of page 20 of my notes, coming from paragraph 42 of Brennan's judgment. Common law does not necessarily conform with international law, but international law is a legitimate and important influence on the development of the common law, especially when international law declares the existence of universal human rights. A common law doctrine founded on unjust discrimination in the enjoyment of civil and political rights demands reconsideration. What do you think about that? Any comments on that?
That topic has actually been discussed in the book. It sort of discusses the Justice Dean's comments in Gerhardy versus Brown, and he actually gives a comparison of decisions that have been made in other countries, and talks about that the common law still hasn't actually sort of satisfied the injustices of our history.
Yeah, that's good. Thank you. Thanks for that, Kelly. You know, what's going on here is that of course, the justices of the court, Brennan and others in the majority, but Brennan being the lead judgment articulating the position, they're trying to find how can they explain judicially and in a way that's consistent with their approaches judicially to justify this radical, I use that in quotations, not talking about radical title, but radical step that they want to embrace, that Brennan says is necessary. In other circumstances, you know, in later topics, we will see that where that radical break with the common law thread has been proposed, we'll see that in a later topic 9 or 10 with regard to principles of equity, then the majority of the court has rejected just a radical break because it's no longer relevant. Okay, but so what the court's doing here, and through Brennan's judgment, looking to international law, I would put to you, international law norms, and basically what they're saying is, look, you know, this is already accepted internationally. The norms at international level are now setting the template. And really, the common law is out of sync with that. It's not that the common law slavishly follows international law norms, but where the position has changed gear, in a sense, the old common law view, if you like, can no longer be sustained because there's no basis for it in law that is more important than the historical origins of the common law position of Australia being terra nullius. And that really was a way for the court to say that, well, this is just a natural step. It actually makes it, you know, from a legal point of view, actually less radical, even though the outworking of the Mabo No. 2 case couldn't have been less radical, actually, in the imagination and in the discussions which followed. But it's important to remember that Mabo, despite its significance, has not been universally endorsed. There is reference in your materials to subsequent decisions of the court which are are reserved about the correctness of the Mabo decision. You should not forget this, and that the law keeps evolving, and as new justices are appointed to the court, they have to proceed to evolve the law and evolve the principles and the rules as appropriate where there isn't legislation that's governing. And, you know, as we know, the great common law method is incrementalism, and I'm a great adherent to that, and I think it's a you know, a good, generally a sound and prudent way to proceed in developing rules and principles. You know, Mabo is in a different category, I think, where we've got something of such significant social significance and societal significance. But generally, that incremental approach is the best, I think, best way for things to evolve. But the point is that, you know, subsequent members of the court have not all unanimously rejoiced about the majority judgment in Mabo. And it's actually interesting, of course, that Brennan himself, subsequently in the Whip Peoples case, was in the minority in terms of the interests of the pastoral leaseholders and the impact that had in terms of the position of the Crown and what they acquired ultimately, or didn't acquire. And we've seen the Whip Peoples case previously when we looked at tenure, and we'll look at it again when we look at extinguishing native title in the first topic in land law. So let's go back to the question, as we must. We wouldn't want to go off on a broad discussion without linking ourselves back to the question, would we? How would you like to sum up? You know, if this was an exam question, I'm not suggesting it's an exam question, but if it were an exam question, as we're now in examination mode, as we have to be, it just says critically discuss. And it specifically says do not discuss the Native Title Act, so I wouldn't want to see any reference to the Native Title Act in your answers, of course. But just critically discuss. What sort of summation would you come to, or would you think would be appropriate here?
Without referring to native title, I would find it very difficult to come to a summation that doesn't include reference to the Constitution. With regard specifically to international law, that even though the court may express an opinion that times have changed, views have changed, there is still a constitutional requirement that international law is enacted in domestic legislation, and without that being enacted, it fundamentally remains an opinion of the court as to whether they should be taking international law sort of, you know, further in terms of observing it within the Australian sort of genre of law. And
we know that, and this is again, you know, we're moving beyond property law, but we know that there is decisions of the court which are absolutely clear on the fact that the High Court's role is not just to give a judicial opinion that's not about a dispute. It has to be a real dispute resolving, you know, an issue that comes before it. It's not just to give an opinion at large. That's not the role of the court within our structure. But having said that, the way that it articulates its views and ideas, of course, necessarily touch on the broader canvas. You know, a question like this, or even a problem-solving question, and I'll even go as far as this, there is not necessarily one answer. This is the thing that students find so bedeviling, that, you know, surely there must be an outcome that we are required to produce if we understand things comprehensively and well enough. Not necessarily, okay? Law is about how well and how skillfully you can craft your argument grounded in law that obviously makes sense it's logical, it's analytical, and it's not fanciful or far-fetched, okay? But I'm going to use a word now that I think is a characteristic of good legal writing. And it's a characteristic, I think, of sound judicial decision-making too, and that is compellability. Are your arguments compelling? Do they meet this benchmark of compellability? Do they show that the view that you're putting forward, the conclusions that you're arriving at, necessarily are grounded in the law, proceed from a balanced understanding of the competing factors, and even though there may be countervailing points or countervailing positions, this is in your view, or the view or the position you're putting forward, is the one which commends itself the most, and you're showing the reasons and why that is so. You do that in responding to a question like this, an essay-style question or discursive type question. You do that also in a problem-solving question. In a problem-solving question, we need an outcome, people. We do not need everything left in play. A client's not interested in that. But there may be more than one outcome that's possible. You're trying to explain what you believe to be the outcome which best commends itself on your interpretation of the legal framework and the legal matrix, whether that be informed by common law rules, principles of equity, legislation, or as Grant's indicated and is alluded to in problem 15, nor international norms, for example, international law norms, which are less specific, but certainly informing how we should understand how things should be at the end of the day. We have done problem question 14 and we have done problem question 15. And it is 12:20. So we've got about 10 minutes left. I'm happy to open up the floor and whatever questions you would like to raise or points, we can engage in that for the remaining 10 minutes of the class.
Just in relation to Mabo again, you asked that question just before about how we might go about answering any questions if they were exam questions. For me, it's around decision in Mabo actually opened the door to where we're going with this whole issue. Prior to that, that I felt that door was closed. And it was enabled to be opened by the actions of Eddie Mabo, who, bringing the knowledge that he had and what he saw impacting upon his property rights, if you like, and his peoples and his communities, how he took that action, working with solicitors and lawyers and all the way through to be able to arrive at that outcome that's been such a monumental decision for this country. So I guess in what I'm saying is, in terms of a lot of these cases, it's how did those things come to be? You know, who drove them as well as the legal decisions that arose from that. What were the circumstances that led to that, and how people saw and viewed their rights and used the structures of the legal system to be able to come to a determination.
Thanks for that, Margaret. I think that's absolutely true. And that's true not just for a decision like Mabo that has huge social and political significance as well as legal significance. It is true for every area of the law. That is the reason why I give you and require you to read the cases and the factual matrices of those cases. They're often complex and difficult to work your way through, because some of them, not necessarily, in the Mabo case, but in other cases, complex commercial situations, sometimes involving interests that or areas of, even in property law, we haven't fully investigated or you fully have your head around, but you've still got to understand the nature of the factual matrix that is informing the dispute that has led to the further development and the application and the development and the determination of rules and principles that give us a particular outcome on that dispute. That's where, in truth, the interest, the fascination lies in seeing these factual disputes and these factual situations within which humanity gets itself involved in. The disputes are about money, the disputes are about power, the disputes are about people fighting with each other, families fighting with each other. The next couple of weeks, when we start looking at equity and problems in interests in land, we'll see that brothers fight with each other, husbands and wives fight with each other, de factos fight with each other. And what are they fighting over? They're fighting over property, they're fighting over money, fighting over what's mine, what's yours, even sometimes down to the last thumbnail or the last toothpick.
The dog. Or the dog.
Or the dog's tail. I mean, it is unbelievable what people will enter into disputes over. But that is the condition of humanity. And as lawyers, we cannot remove ourselves from, as students of law, as lawyers, of course, you're in the mix of that. I think there's two challenges here. As students of law, you must remember that that's what stands behind and drives the great framework and the evolution of law that we have, principles, rules, structures, institutions, so on and so forth. When you go out there into reality land and practice or work in environments using your law, you must always, in my view, come back and remember the underlying framework of principles and ideas and concepts, because you can never know when these things become important and relevant in a particular practical dispute that your client is having with some other party or interest. So thanks for that, Margaret. Any other thoughts? Ideas, points, anything?
Just going back to the Mabo thing as well, just not long after the decision, the Keating government brought in the Native Title Act, which they had a hell of a fight getting it through the Senate, if I remember rightly, as something that was going to be passed just before Christmas, and no one was allowed to go home until they actually got passed. Had that act not been passed, would, like, say, if you had a different makeup of the High Court, would that decision then be able to be overruled? And like similar as Howard brought in that, 10-point plan in regards to the Wick decision, like in things like, would that have been able to undo what was actually gained through the Mabo decision, I wonder?
That's a good point, Michael. Anyone want to respond to that?
I just take your point earlier about the incremental nature of what this is all about. Ruling in Mabo, as I said, set a foundation for something, and it's always, it can be used then as a basis for going forward. If there's other challenges mounted against it, you've still got something there that that can be used and employed to construct an argument, to have a discussion about the whys and wherefores of further legislation that may come through. But I particularly like the fact that it is incremental and you use it to build on to go further, higher, wider, however it might be.
Anyone else?
I think people that actually, sorry.
No, Kelly, please, yeah.
I was just going to say, we're talking about sort of Mabo and the cases, but it's actually funny when you look at the practical application of the Native Title Act, and when you actually do a native title register search and get the results, and it gives you that which tribes can do what with what public land. I don't think people actually appreciate, it scares people actually when you do a native title search, what comes up. And even though I've got this discussion about the cases involved in native title, it's funny to actually see the practical side of the application of the Native Title Act.
That's good. Thanks for that, Kelly. And that's one of the other reasons why I've separated this broad debate that we can have about the common law recognition of native title and the social and the political and the moral questions and issues that necessarily gravitate from that, on the one hand, with the mechanics and the logistics that are now part and parcel of the legislative regime, and how you actually go about making a native title claim, what are the rights that native title holders have pursuant to the legislation. And when we cover that topic in land law, I'm going to give you and show you some documents and material from the National Native Title website, and just look at some of that landscape. And it is interesting, and it is more practical, and we need to see that out working. And that's what legislation achieves. It fills in all the detail and provides the environment where something can happen and all the boxes can get ticked and the T's get crossed and whatever, that the broad, the open nature of how the principle can be encapsulated in a decision of the High Court isn't really possible. But then and I'll finish on this, the broader tension, of course, which travels through all areas of law, not just property law, is this tension between the legislature and the judiciary. And that affects this area of law just like any other area of law. And as we see, and we'll see increasingly, particularly in land law, we've got a current review looking at key pieces of property legislation in Queensland on foot at the moment, not finished, not done and dusted. And increasingly we'll see the relevance of those key pieces of legislation to property law and the great body of principles of general law, both common law and equity, that also inform the legal framework that we have. But that tension between legislative authority and judicial discretion and judicial decision-making is ever thus within the common law. It is a great strength of our common law system, and it necessarily informs how we understand the legal framework operating day to day. Thanks for joining, people. I'll be posting some information early next week about remaining tutorials, and I've already indicated I'm going to be offering additional tutorials in weeks 10 and 11. I want to finish the substantive topics by end of week 11, so that you're all done and dusted from that point of view. And then I'll be offering a further additional tutorial, an examination preparation tutorial in week 12. And there'll be information about the final exam early next week as well. And that will be, I've already posted something about that through an email to you. Again, that's something you'll do approximately over a 48-hour period toward the end of the review week. So I'm proposing to open it on the Wednesday, the 28th, and it'll be due for submission on Friday evening. I've tried to balance in thinking about that time slot. I've taken on board people's comments to me about time windows that work and don't work, and weekends and daytime and daylight hours and nighttime hours and so on and so forth. So I hope that that's a happy accommodation for everyone at the end of the day. And I hope people find the final exam sufficiently challenging.
I think Moodle will be sufficiently challenging. It seems to be a nightmare, that thing. Moodle, yes. Thank you, Michael. Thank you for identifying that. Moodle has been challenging. And look, what I've been doing with that to some degree is, using it in a way that I think it hasn't been necessarily used as much by others previously. So there's, learning curve there from all perspectives, but it's certainly, I think there are benefits there, and they can be used, but, there's challenges as well. That's clearly the case. But we've, most of us have navigated our way through that, which has been good in the end.
Yeah, but thanks for that point, Michael. It's important to you know, not everything is a is a plain sailing ship, that's for sure.
I found as long as you save everything on a Word document, at least that way you don't lose it when it all disappears. So.
Well, you know, that's an important point to make as well, is that you should always, in everything that you do, be prudent, okay? Yeah. So that save things. Don't just submit something through an electronic space. This is a good lesson to learn going forward, you know, in what you'll do in your, you know, work once you finish your degree. You know, if you're filling in documents, for example, if I come back to property, filling in documents in an electronic form and conveyancing, for example, is now very much moving into an electronic space. If you're filling in critical information in an electronic document that somehow disappears off the screen, well, you know, it's not great if the client wanted this document lodged by a certain time. So we all have to remember that there are, you know, foibles and frailties within the electronic space, and we have to always remember to operate in a way to protect and preserve and keep copies of things as best as we can in an appropriate way. So, yeah, that's good.
Okay, bye guys.
Bye. Bye for now, people. Bye for now.
Bye, everyone.
Bye, everyone.
Bye.